Hello, and thank you for joining us for the second episode of the SLW Institute's Patent Analytics webinar series. Today's episode is Using Patent Landscapes to Develop IP-Rich Products and Valuable Patent Positions. Please feel free to enter any questions in the Q&A feature in the Zoom menu. A webinar recording and the presentation materials will be emailed to all registrants. Today's presentation will be moderated by Steve Lundberg. And with that, I'll hand things over to Steve.
Thank you, Michelle, and welcome to everybody to our second episode in our Patent Analytics series. I'm happy today to welcome back a few of the presenters from our last call. Janal Callis is returning. And again, Janal is principal at Schwegman. Janal brings a chemical engineering perspective to this technology. And Janal does a lot of FTO work for her clients and has done an awful lot of patent analytics and landscapes. And today, Janal will be talking about using forward and backward citation landscapes. We have also with us today new Micky Minhas from formerly the chief or head of patent licensing and strategy at Microsoft and now the senior vice president at Marconi. Micky's also a professor of law at Franklin Pierce Law School. Micky, thank you for joining us. We've got Andre Murray, who's a principal at Schwegman, and Andre has represented a great number of startups in the Silicon Valley and also very large corporations out there. So Andre brings a great perspective, has done a lot of landscaping work. We've got Mark Stignani joining us again as well. And Mark is the analytics chair at Schwegman Lundberg and does a great deal of analytics work for our clients, including a lot of landscaping. So with that, let's flip to the next slide. So, what is a patent landscape? Well, essentially a patent landscape is an analysis of patent data that illustrates composition and comparisons of patent portfolios and positions, as well as reveal business, scientific, and technological strengths, weaknesses, and trends. And as we go through the presentation today, we'll demonstrate some various uses of these, and we'll finish up at the end with Mark Stignani. He'll give us some of the bells and whistles and graphs and charts and talk about the tools. But to get this thing kicked off, let me go to the next slide. This is a little bit of what we're going to learn today. We're going to learn about who uses landscapes, when they're used, what kind of strategic insight is provided, some different types of landscapes, something about how they're generated, and an overview of the tools. And I think we bring several different perspectives to this. We've got, Micky can speak a lot to very large corporate perspective. And certainly Andre can speak from the perspective of Silicon Valley startups. We also have Janal can bring the perspective of the private practitioner representing companies that are interested in drilling down into more specifics of who's doing what and landscape of inventing, if you will. And Mark Stignani also brings a wide variety of perspectives from his former work in corporate practice and also as working at Schwegman now. So with that, let's move it over, and I'll hand it off to Micky and let him talk to us about landscape fundamentals.
Great, thank you, Steve. Hi, everyone. It's Micky Minhas, and as Steve mentioned, my background is mostly from large corporations, so it sort of brings that perspective. And so when I refer to sort of clients, I'm thinking about more corporate clients, product groups within corporations, and from some of the experiences from managing attorneys who are supporting clients within corporations and so on. So first is like, what do you use patent landscapes for? And I think there are a variety of reasons there, but I think it's sort of important to really understand that first, to understand where, like the why behind that request that's coming in. It can be a full range from simply just wanting to know, who has patents in this general space as a client group might be entering a new field, to something that's really driving a true, driving some outcomes with respect to licensing or acquisitions or something along those lines. I think that the amount of time one can spend on a landscape is very variable, and you can spend an awful lot of time going through. So, I've found myself in situations many times where the amount of work done was really overkill in light of what the person wanted it for. Sometimes teasing that out of the executive who's making the request is helpful to do, because perhaps they're not really quite sure how. And some of the techniques I've used there before is often sort of pushing back on the person asking the request, and asking questions such as, let's just assume for a moment that it's the worst case scenario and that our biggest competitor has a significant patent position in here. What would we do differently? And surprisingly, a lot of the times that answer is nothing. We wouldn't do anything different. And that helps you sort of scope, okay, this is sort of like just sort of informative, wanting to know how it is. And that I think can help quite a bit in terms of scoping the amount of work that needs to go into it. But on the other hand, I think it can be, very, very helpful just from a pure educational perspective, bringing to light some of the companies that are in that space, or often clients will have a good understanding first of all of who are other companies in that space that they might be aware of or even worried about, or who was an early player. And so often with landscapes, I'll start with more business data than anything having to do with patents, just to understand who did what when from a company perspective, and then looking at IP, through that lens. And so there's a little bit of chicken and the egg. If you start with companies and you find some patents will then identify more companies, and you sort of grow from there. So I find that, starting from the business side, to be a little bit more targeted and a little bit easier point to start with, and in the sense that it can help confine the scope of this. And again, I'm saying this from a background where my background is primarily in software, semiconductors, or telecom, where there are thousands of patents that are applicable to a given product or a given space. And so how do you, since the ways I'm describing sort of help confine the amount of patents that one has to actually consider in the landscape that you're considering. As I mentioned, it can be anywhere from education to the other end of the spectrum, where you're identifying potential acquisition opportunities, or identifying licensing strategies, where you determine there are some major players and perhaps some roadblocks that you need to deal with, and that can really help inform how you go about that licensing strategy. Now, so licensing and acquisitions, that's always company to company, right? It's not necessarily patent by patent, and so that means a licensing strategy really has to consider all aspects of your company and its portfolio vis-a-vis the other company that you're concerned about, not necessarily just the space that you're that you are focusing the patent landscape on, but rather where does that competitor, where do they make their money from? What products are they in? So that analysis will often be well beyond the scope of whatever the patent landscape is, but that's really more of a company versus company disposition. We can go to the next slide, please. On the previous one, I did note that it can help inform a filing strategy, and I use the word inform because it's really, I find it very difficult early on to determine how a landscape can help identify filing strategies. And again, I'm referring to fairly crowded areas of arts of fields where there's thousands and thousands of patents. I've found that over time that most of the useful patents that can be used in licensing and litigation and so on tend to be around the 8 to 15-year-old time range. And therefore, just by that age of the case, I find it difficult to make informed decisions on subject matter about what to file in and what not to file in. However, it can be helpful, I think, in terms of geography, in terms of determining, if there are certain geographies that are light in filings in given areas. The curve on the right is, I think, what most landscape studies look like, and I'll just call it the general hockey stick, where it's fairly flat for a number of years. Then there's some sort of inflection point, and then a spike up. And I find that, the most interesting patents is sort of right around that inflection point time. So right where, the end of the flattening of the curve and before things start to really swell up. Once the patents start going in that vertical nature, now it's sort of like in the bandwagon. Everyone's filing on certain areas. And some examples of where that is today is like in AI or quantum, 5G and blockchain, depending upon the time frame you're starting with, talking about. But each of those areas is sort of in this vertical stage right now where, there are so many companies filing so many cases in that area. And, one word of advice I would give is I watch out for the phrase, and this is from managing attorneys and clients, where I hear portfolio building mode. Because portfolio building mode often can be described as just simply lowering the bar and filing more cases, which I have found to be, cases you end up later on just abandoning those cases because you're sort of in that vertical stage of it. Instead, what I think it's important is to recognize that is the time where one should be, really considering an acquisition strategy or a licensing strategy with respect to those patents that are in that flatter area or around that inflection point. You can't file more cases and sort of catch up and replace time, right? Those extra cases that in the vertical part of that curve are not going to help you, most of the time deal with the companies that own the patents in that flatter part or around that inflection point part. So I would suggest you resist that temptation, but rather drive that conversation towards maybe we should look at acquiring or licensing what is needed for those companies that were frankly there first. That's what I have for now. If folks have questions, feel free to put them into the Q&A section. Other than that, I'll hand it off to the next speaker.
Sure. So yeah, if anyone has any questions, please enter them there in Zoom, and we'll take them typically as we go. Thank you, Micky. That was very instructive, and I guess I'll hand it off to Andre, and Andre, why don't you take it from there?
No, thanks, thanks, Steve, and thanks, Micky. Thanks for that. So basically, I'm going to be just really diving a little more into the kind of why of why you may want to conduct a patent landscape, and the way I'm going to focus on is probably really as input into a business a business strategy. I think there are many reasons why you may want to do patent landscaping, and I think Mark and a few other speakers will get to that a little later. But my primary focus here on is for startups and perhaps medium-sized companies who really are looking for inputs into a patent strategy. And what the slide here really reflects is that we really need input from both the business environment and the IP environment into the patent strategy, and that's echoing what Micky said. And the first thing with the so what I kind of break it out into two areas. The one is the kind of business landscape, and the other one is the IP landscape. So and I think Micky was absolutely right in pointing out that the business information educates the IP landscape, and I think the IP landscape can also go back to educate how you do your business landscaping. So for business landscapes, I kind of normally focus on two areas. The one is know yourself, and the other one is to know your competitors. Particularly for your knowing yourself. I worked with kind of medium and actually even larger companies who may not actually be fully aware of market conditions, both product and geographic, may not really have a full picture of the supply chain in which they're operating, or even the revenue from their products and technologies. And particularly as companies grow, this is it's somewhat understandable. I think legal might sometimes get a little isolated from this. One recent example is that we were working with actually a medium-sized company who were really not aware of how much of their revenue was being generated in Australia, and also how dominant they were in the Australian area, but also what the competitive landscape in that area, and that was good input into their patent strategy. So I think being able to identify where you fall in the supply chain, looking at both upstream and downstream, is particularly important as well. And just really knowing also, if you're sourcing products or information and who you're supplying to, all of that information can be a valuable input. But at the end of the day, I think if you're looking to maximize the return on investment on your IP budget, and you want assets that are valuable, very often a mapping between an IP asset, and a revenue contribution from a particular product or technology is very valuable information to have. One example for know thyself is, we had a client who was in the IP geolocation space, and what we used there was we looked at who their competitors were, but we also looked at where they were getting certain information that was input to their process from, and also who were their customers, who was using this IP geolocation information. And we use that to kind of drive, there's all these use case scenarios for our output, for our product, which is just this information. But if we could file some IP around those use cases, even though we, the company, are not doing it, that turned out to be some of their most valuable IP assets, because particularly if a customer is looking at them versus a competitor, and we can say, hey, well, FYI, we filed an application or on a use case for our output. It is pretty useful for the salespeople, obviously, to be able to use that information. And then again, for your competitors, what are their key products? What are their key technology areas? What are their key markets? And what is the revenue in those areas? You may have a major competitor who's a big chunk of their revenue is being generated in Europe or Japan or Korea, and from a patent, that's very useful information or input into your patent strategy. I always say I think the most valuable and useful patents you have are not necessarily those that cover your product, although those are of course important, but those that cover your competitors' products, or your competitors' potential products down the road. So for this business landscaping, if you're in a large company, you may have an internal business competitive analyst capability, and speaking to those people, legal can kind of gather that information. But for smaller companies, and actually even for larger companies, we've actually used external business consultants who will kind of scour SEC filings and a bunch of other proprietary resources that we don't necessarily have access to, and will often surface very interesting information over there that the company may not even have been aware of. So we've had quite a bit of success in kind of putting together a deck, which is like, here's how the analysts are viewing your business, and here's how they're viewing the competitive scenario. So we've had good success using that type of resource. Okay, so just moving on to the next slide. Okay. So basically taking this business intelligence as an input, there are various types of landscapes that we can generate. Understanding, again, just emphasizing that these landscapes are all input into patent strategy decisions, a number of them that Micky touched on earlier. So one of the common ones is kind of a technology landscape, and this is where you identify patents held by third parties in particular technology areas. Those technology areas can be, you could use the patent office, tech ontology, or the technology classes defined by the patent office, or you can very often self-define a technology ontology that's more meaningful to the company, and there we can have a look at who owns what in different tech areas. I think this is, a tech landscape is kind of useful in that it may reveal a currently unknown competitive threat, both from a business and IP viewpoint. And this can again provide input back into the business landscaping, where you might find someone here is like you weren't aware of, and it's like, oh, let's go have a look at let's add them to our business analysis. The second type of landscape, a common one, is competitor companies, and this is really a specific list of companies, perhaps derived from your business landscape, and trying to see what they own, where they own it. It's from an IP perspective. Over here, in addition to using the business landscape as an input, you may also want to look at litigation information. Who are the aggressive litigators or licensing entities, and add them to this landscape to see how many patents they own or assets they own in a particular area. And then the third one, this is kind of an interesting one as well, is kind of a reference company landscape, and we find a number of clients are really interested in this, just to benchmark their patent activities vis-a-vis some other companies, just to make sure that they're, a common question of patent strategies, like how many patents should we be filing, and looking at what other companies are doing is very interesting. Sometimes I'll be surprised to find that a competitor is not filing any patents at all. And other times, that one of their competitors may be very aggressive in filing patents. But even beyond that, a company perhaps in the same broad technology area, but not a competitor. So we've had a number of clients who said, hey, we'd like to see what company, what these unicorn software companies that, for example, in the past, where were they at year 1, year 2, year 3? And they just use that as an input. It's like, okay, we see, there are these different unicorn companies, and this is how heavily they were filing at these, different stages in their life cycle. Not to say that you want to emulate every reference company, but it's a data point, and can be useful. So finally, just to wrap up, again, what do we do with this information? So now we've got the business landscape, and we've got the patent landscape, and I think really, when it comes to input into patent strategy, the one thing could be threat assessment for particularly current products. If there is a company that's competitive and is known to be litigious, you may want to do a very focused freedom to operate analysis on selected assets over there. Again, probably don't want to do anything too broad because that can get expensive, but that is one action item. I think also Micky touched on portfolio, growth strategy, and we've had some clients who've identified a weakness in a particular geographic area or in a particular tech area, and totally agree with Micky. Don't lower the bar on what you're filing, but what they've done is adopted an inorganic growth strategy and really gone to the market with a view to acquiring some assets so they can beef up their portfolio with. And if you look at a number of unicorn software companies, you will see that they have acquired numbers of patents and portfolios from some incumbents who are either looking to get out of a tech area or for other reasons may have sold stuff. And then also with this information, if you're looking at more organic growth strategy, what we've seen some clients do is not looking, at the current situation, but where are we going to be in 5 years' time, and really done some, forward patenting in specific tech areas. We're getting the top technologists together and doing some blue sky thinking and really doing some IP design actually out ahead of product to get some patents in place that they think may be valuable, down the road, where they perceive a weakness in their patent portfolio, or where they think they might need to shore up their IP position vis-a-vis a particular competitor or a threat. So that's all I have for now. With that, I'm going to hand over the microphone to Janal.
Hey, before we move on to Janal, though, we have a few questions, and we've been answering these questions in written form as we go. I'm not sure everybody can see the questions that are asked or not. I'm not aware of whether or not everyone can, but there was a couple questions I thought would be interesting to get bounce off the panel. I mean, one of them is, you know, a really good question, like, by doing landscaping, are you potentially exposing the company to willful infringement problems by being aware of, you know, patents that otherwise you wouldn't know of or have actual knowledge of? Any reaction to that, Micky or Andre or Mark or Janal?
Sure, I'd be happy to start the conversation. So yeah, I do think it raises that issue, and to me, there's sort of a balance of, you know, would you rather know that information and then employ either an acquisition or licensing strategy, or would you rather not know that information? And I almost always have leaned on the side of rather knowing that information and dealing with the issues that are at hand, as opposed to sort of staying consciously, you know, consciously blind from what that might be. Each company might come to a different conclusion on that, and somewhat of it depends on just your sort of your willingness to your company's willingness to sort of deal with these issues. I say that also, that though I've generally worked with companies that had very strong patent portfolios, and so even if there were patents, you know, that another company had that were problematic, you know, you could find yourself in a kind of in a détente situation with that company with other patents that you have that read on that company. So I do think it sort of depends on the nature of your company, your current patent position, and your willingness to take on these issues.
Yeah, and then yeah, Steve, I'll just add to that. I think you know, a lot of these landscapes are at a very high level, and you know, for willful infringement, I think you need to actually have done a claim to product comparison. So if we're just looking at very broad numbers and broad technology areas, I don't think that. Well, I think that mitigates the risk of you know, willful infringement with respect to those. But I agree with Micky there. You know, if your landscape does reveal a company that you know, has some high quality patents, is a competitor or known to be, you know, aggressive in licensing or litigation, in that situation, you may want to kind of dive in and do an FTO, freedom to operate, and there, you know, I think I totally agree with Micky over there. You want to know about those problems rather than do the ostrich head in the sand approach.
Yeah, and I also, is a really sharp divide in in-house counsel's positions on that. It's not in between in nearly any case I've ever come across. Either they want to see it or they don't want to see it. But, you know, the mitigation aspect of it, whether it's a purchase in or a license, or even writing your own patents to, you know, cover what you do and hopefully get an examiner to distinguish and differentiate with that discovered reference in your own filings and prosecution. I think, you know, I definitely fall in Micky's camp. That's better to know than to be entirely blindsided or not know.
Hey, Mark, as long as I've got you going there was a question that came in that you answered, I think, on the side, but I thought it was worth talking about for a second, which is, you know, how landscapes can help with technology commercialization. And by that, I suspect maybe a university may have some technology they want to commercialize, and they're trying to figure out who to approach. So you had an answer there, but you want to talk about that? Maybe Micky wants to join in, or anybody else.
Absolutely. Universities tend to get into technology a lot earlier than a lot of the standard patent filing community. So they're always kind of looking for ways to give a hint or get a hint on where that technology can utilize. So a lot of cases a landscape will show you the people who actually play in that playground using, you know, you can use semantic search or a natural language tool to look at the claims or some of the other really key aspects of technology have disclosed in patents. So it's a fishing tool, you know, if to be used in the landscaping area. It's always a starting point because, you know, it is, as Andre put it, a high level look at things. But you can figure out who the usual suspects are, and then you can figure out who are the people who are, you know, behind in filing if you're getting into it later in the marketplace. So, you know, universities especially have, I think, a useful outcome here by looking at landscapes for their new technologies that the professors and researchers are coming up with. Micky?
Sure, I can chime in here. I agree with those comments. I'd add, and this ties in another question of looking at papers, non-patent literature as well, as giving a leading indicator as to who else might be interested in some of those same areas. I would certainly include that as you know, most patents, patents you don't see for a good 18 months, but the papers will often precede the patents and give some great insight into different companies or entities that are working on those different areas.
And I think Janal will actually speak a little bit to drilling into, down to the level where you could really find out who's got an intense interest in a given area, particularly, in the chem practice area or pharmaceuticals or whatever. I'm trying to think, are there any other questions? I think we'll move on to Janal then and come back to questions later. Go ahead, Janal.
Thanks, Steve. And thanks to everyone who's listening to this webcast. What I'm going to talk about are landscapes for cheapskates. And what this involves basically is forward and backward citation analysis. And it can be as simple as looking at office actions and references cited in IDSs in a particular, either an office action itself or the patent prosecution of a single patent, or in more complex cases, it can be actually the creation of a competitive matrix based really solely on cited and citing references. And there are certain, well, the goal is to wring as much information as possible out of forward and backward citations. One assumption in this type of analysis is that art, which would be cited by entity A to a patent office, it amounts to information which flows from the owner of the art, entity B, to entity A. And over time, for one of these more competitive matrices, you also look at entity B and their citations from entity A. So this would be information that flows from entity A to entity B. Additionally, over time, entity C may cite information from entity A. So this would be information that flows from entity A to entity C. Could I see the next slide? Next slide. Okay, this is a particular example looking at references cited in an office action against the Inovio patent US 10-548-971. In this case, the examiner cited a reference from the Pasteur Institute, a reference from Novavax, and a reference from Ligosite. What was of interest is the subject matter of Novavax was such that I took a closer look at who was citing or did Novavax cite references from any other companies. And what came up in the search was New York Blood Center with 79 patents and 26 families. And what this indicated is that it would be a good idea to take a closer look at the New York Blood Center patent portfolio to see if there could be any problems vis-a-vis that 891 patent. In looking at forward and backward citations for Ligosite Pharma, I noted an interesting thing, which is that a company not with patents not cited in this particular office action, Takeda Vaccine, seemed to be drafting off of Ligosite in that Takeda had cited 20 patents of Ligosite within its portfolio that were related to the patent that was cited against Inovio. This is significant because it meant that it was also useful to take a look at the Takeda Vaccine patent portfolio, which is huge. So you'd have to determine methods to whittle it down. But it also shows that Takeda is drafting off of a relatively small pharmaceutical company. And what happened after this, a couple of years later, was that Takeda Vaccine actually acquired Legocyte Pharma. And what I've observed over time is that when you see these kinds of imbalances, what typically will follow is either the small company will be forced out of business or be purchased by the large company, or if the companies are more comparative in size, that there may be a patent infringement lawsuit. Next slide. Okay, this is another example of looking at references cited in a patent prosecution. The patent application under consideration was the Epicor patent application. And it's a relatively simple case where there were 4 patents cited against it, one owned by Elwa, one owned by Tricord Holdings, one owned by Emron, and one owned by MC10. And what I did in this case, just to see if there was anything else to be gleaned, was I looked at the size of the patent portfolio, which was revealing and provided useful information. And that is that Emron in particular and MC10 both have very large patent portfolios in this area. So it is in Epicor's interest to study those 2 portfolios further to determine that whether there are any issues or problems in going forth with their product development. So it points out a problem which may or may not have been known before looking at this office action. Next slide. Okay, and this is this last example is a slide showing an actual competitive matrix, the output from that. And it's in the area of deep brain stimulation. This isn't current information, it's at least 10 years old, but I still thought it was quite interesting. The patent portfolio that I started looking at was NeuroPace, which had 8 patent families. And in looking at the forward and backward citations, I could observe that there was interaction plus both information being exchanged among NeuroPace and Medtronic, and NeuroPace and Cyberonics.
Hey, Janelle, can I interrupt you for just a second?
Sure.
This is like a 10-year-old slide, but I just wanted to make you raise your awareness that Dexcon is a client of the firm. So in case there's any conclusions drawn here that we don't want to share, which I don't think there would be, but I think we should be careful about discussing that slide, albeit a decade old. So
yeah, there are no conclusions.
Okay.
Yeah. What is interesting is that it looks like the share of information between NeuroPace and Cyberonics is roughly equivalent. They're receiving as much as they're getting. In the case of Medtronic, it looks like there is there's more information being taken from NeuroPace to Medtronic. Medtronic is drafting off of NeuroPace. Similarly for BrainGate. Now, what is interesting is that, to my knowledge, there never was any litigation among these companies, and these companies, Cyberonics, NeuroPace, Medtronic, and BrainGate, are all still in business with their own products. So it is probably the case that the products under development were distinguishable enough from each other so that even though there was this exchange of information, there never was an issue of patent infringement. The other 2 companies in this graph or this diagram are Northstar Neuroscience and Advanced Neuromodulation. Now, Northstar Neuroscience subsequently went out of business and the patent portfolio was sold to St. Jude. And then Advanced Neuromodulation was absorbed by St. Jude. Advanced Neuromodulation seemed to take heavily from Northstar Neuroscience in terms of information, and NeuroPace as well. But in present day, they're owned by St. Jude. And again, I don't know of any litigation among St. Jude and any of the other companies. So the overall, the competitive intelligence, our in competitive matrix diagram can show a flow of information among various companies which are competitors, which may or may not be, I guess, important over time. Let me know if you have any questions. Thank you.
Thanks, Janelle. And then I think we had at least one. I don't know if anybody wants to venture an answer for what to do if you're just starting down the path of commercializing a portfolio. I think there's so many companies out there that can help you with that, that maybe some of the panelists could share information later in terms of referrals. But anybody want to comment on that topic at all before we move on to Mark? Sounds like Andre.
Well, yeah, I mean, just to say, kind of, commercializing it and and even licensing a portfolio is tricky and difficult, and there are a lot of nuances, a lot of considerations for each portfolio. But I would recommend consulting kind of with a licensing expert. There are a few companies that can kind of help with that, and maybe after this we can kind of just circulate a list of those companies.
There's a very long list of people that do this work. But one of the things I would support here is that, it's much easier to think about licensing and monetization as you're building your portfolio rather than reaching a point in your development going, who can we sell this to? Because it really helps your build of the portfolio as you're going forward. So there's my 2 cents.
Well, Mark, you want to take it from there?
Will do. Thank you, everyone. Again, hopefully everybody's enjoying the questions here. I have a very simple way of thinking about this. I have to say that Micky has, done a lot of, I think, very good disclosure on how to build a better lab. So, I always like to be more simple with my landscapes. I find that, when I get a client who's asking me, how big and how long, a particular whole marketplace is, I tend to try to carve that down into a tinier review process or a tinier statement of work, simply because it's really hard to answer big questions using simply landscapes. Landscapes, as I mentioned, are a starting point. A lot of times my clients will ask me to reverse engineer somebody else's filing strategy. And, again, going back to Micky, who did what when, I like to integrate things like LinkedIn into my analysis of my landscape, because who the in-house person is or who the executive in charge is has as much to say about a filing strategy as the patents themselves. And I find that time slicing your data is really, really important. Also, landscaping, depending if you are into litigation financing or into licensing or into assertion, each of those has a different set of questions. So in many cases, I think that building a landscape is, the best landscapes are done when you have a good set of questions to answer. And I've thrown a list of the questions out there on the right-hand side. The questions also vary if you're looking at M&A, if you're looking to buy into a marketplace, or you're doing actually new product development. We try to advise our clients to begin analytics as they're building their portfolios, have the landscape happen, as early as before they're starting new product development, so they have a sense for how green or how red or how blue the ocean is in their movement forward. Next slide, please. So a lot of times I try to help people work between the bookends. Somebody asked earlier, who are the service providers? In a lot of cases, the service industry is very large in this area because it's so hard to do and marshal the resources internally to do good manual landscapes. I used to do them in the 80s by hand at Honeywell, and they're seldom repeated. And so you end up with this beautiful snapshot of it has some good business data, but it was so painful that nobody ever wanted to repeat it. And then the other side of the bookend is you've got these automated tools now that will give you lots of automated data, but again, with garbage in, garbage out, you don't have the same expertise applied. So going back to my earlier statement about start small, I think starting small, reviewing, validating a good automated result helps you bring this forward so that you can iterate an automation step using the various set of tools as you're going forward and walking to get through this. I find also that people who are relying upon an automated platform for their landscape tools often stop using it after the first 5 or 6 months of use, simply because it still requires effort. So try to find the happy medium in these hybridized solutions as you go. We like to hand a dashboarding tool off to our clients so that they have the data that we're out in our dashboard, so that as updates happen, as new pair data becomes available, you can see who the usual suspects are. So if you're in the automotive industry, you can see the major players, and also as new people bring technology forward, you can identify them more quickly. So let's move to the next slide. And let's talk about different types of views that we use for landscaping. This is one of my favorite non-technical views. This is a view of 2 different companies in the 3D printing business. This is typically a view I have one slide on that I want to talk about comparative running between 2 competitors. And this is invariably the slide I will go to if I'm talking to a non-technical person, non-patent person. Now, I tend to modify these slides significantly to modify the words being used here. This is just generated by a machine just to show the awkwardness of some of the words used. But if you're talking to a non-technical person, this is a good way to show proportionality. It's a good way to show kind of relevancy, ours versus theirs. It's very C-suite related. Now, this is about as complex as I get in visualization. I will never present comparative topographical mapping that a lot of the commercial providers give, just because I personally can't explain it. So next slide, please. I do like using CPC codes to generate comparatives. It is probably the most objective and granular accepted comparison tool out there for landscaping. It's about 250,000 different nodes of granularity in this as it is. It is a proxy for reading patents. So if you're looking at large portfolios, again, it's also a starting point, but it's also, I find that, in conjunction with other landscaping tools, it has quite a bit of relevance in your discussions, especially as you're getting down into the weeds with your technologists. Next slide. So one of the things that I think has come out lately is prosecution analytics. In landscaping, people in the high level of landscaping rarely get to this point, but I find it is a really good comparator tool when you're looking at your 2 relative portfolios between, at this point, a US-based one, because it's really only available in the US. You can figure out how much effort they put in the portfolio. You can make some estimates about the level of investment, the quality of the prosecution that the law firm has invested, or the outside or the in-house counsel has invested into the portfolio, and it gives you a much better scorecard of the actual parallel aspect of the portfolio. And one company may have a high degree of office actions, a high degree of RCEs, in which I would suspect there's a lot of lower value patents in that portfolio. Quite the contrary, the longer your prosecution lasts, I find rarely do you end up with a better, broader patent out of it. So, I mean, this is another way of doing landscaping. So there's about 6 or 7 different levels to look at landscaping with. Next slide, please. I also like country comparison or geo-slicing because what it tends to do is give you a much better guess at how the level of interest of that company's investment, whether it's a product line or even a portfolio in general. What do they care about in that marketplace? This is much more of a financial or investment indicator than it is anything else. This also allows you to kind of start figuring out If you see a lot of LLCs and licensing corporations and stuff, you can start to kind of piece apart their tax filing strategy as well by doing a geo-slice of their products and seeing comparing where they've got factories, R&D centers versus where they have sales outlets. So another way of quickly landscaping something as well. Next slide, please. So in my key takeaways, as back to what Micky said, get your question right first. Definitely analyze small and move yourself into a much more broad statement of what you're looking in the landscape. I love to, this is my first ability to use Occam Razor in a presentation in quite a while here, but generally, if you have a landscape that has the fewest level of assumptions in it, it's probably the right inference to make out of it. And again, definitely look into prosecution because of the nuances and inferences that you can make from prosecution data, I think has a huge implication in your ability to give your client a good answer about a landscape. Next slide. And I think at this point, anybody has any questions?
So let me take this back for a second here.
Yeah.
So first of all, I wanted to go back and just mention that, Janelle, I misread your slide. We weren't representing anybody on that slide, so that was my mistake. Actually, it was a different company, so sorry about that. Just wanted to be better safe than sorry. And so we have a question about using, that was answered already, but it was about using applications versus just patents and landscapes because they do kind of overlap. Any comments on how not to double count or whether or not applications are more interesting or less interesting than patents?
I think I answered that one off there, so I'll just enhance my answer as other people are wanting to chime in. Applications are a really good trend indicator, and if we go to some of what Micky had said, is that non-patent literature is also a really interesting tool for looking at trend lines in landscaping. So I don't count them as good coverage. I count them as trends or indicative of trends, and also kind of an ongoing, if they're a continuation versus so you look at the priority of it, and if there's a continuation or continuation in part, then you see there's an ongoing commitment to that line of patents. So I tend to look at applications as useful, but if you're looking for freedom to operate, then they're things to watch.
So
yeah. Steve,
yeah, go ahead, Andre.
Yeah, also just on that, I think with technology landscapes where you are, categorizing IP assets in tech areas, one common issue is, do we categorize something in only one tech area or multiple tech areas? And, there again, do we count an asset? If it happens to straddle technology area A and B, do you count it in both? I mean, personally, I just find it useful, for example, in our ClaimBot tool, you can tag an asset with multiple tags. And I think it gives you a more honest view or perhaps a broader view of your portfolio if you do allow for something to be counted, an asset, if it does straddle two, to be counted twice, particularly if you're comparing two portfolios. If you're only allowing a single tag or category per asset, that can kind of give you a somewhat limited and I don't think holistic view of the portfolio. So I just wanted to add that.
Yeah, if I could just chime in as well, I think I do want to differentiate between, and I think Mark brought this out, difference between a landscape search and a freedom of operation search. Recognizing that a landscape search might lead at some point to a freedom of operation search, but typically in a landscape, you sort of want to figure out who's doing what when. And so I tend to lump together patents, patent applications, and papers all into that, so you can identify really the companies and sort of where they're trending. Yes, at a layer deeper, then you may want to narrow it down to just patents if you're seriously concerned about somebody actually having rights in those spaces that you're worried about. But I would call that closer to a freedom of operation search that you would do later.
It's actually a good, I think partially maybe someone could comment on actually a couple topics left. One is what the relative costs of these landscapes are, and then number two, how a landscape search does feed into or maybe is used as a starting point for an FTO search. So whoever wants to go, jump in there.
Oh, I think I gave a partial answer to that as well. I mean, landscape searches, can be as cheap as $300 depending on the company you're using, and all the way up to, 5 to 10K. If you're, if your question is really hard, it requires a PhD to answer, you should count on paying more for it. Also, the sophistication of your searcher or your landscaper is also going to be a key factor in whether it's expensive or less expensive. So you have a lot of different factors in that, and we keep a list of about 25 or 30 landscapers in a spreadsheet. So we tend to try to find ones that do good work and return to them as they've done good work for us previously.
Yeah, to add to that, I do think we talked about this earlier on, but I do think that if one starts sort of on the business side of the equation as opposed to the patent side of the equation, that can help keep costs down as well, because now you're, a lot of your searching is just going to be by assignee to figure out what those companies are doing, and that can help sort of like scope that search. And I definitely like to layer it, starting something that would be higher level and lower cost, and then drilling down over time only in the areas where you really feel like you need to drill down.
So Janal, your landscape was very interesting, the examples you gave, because they're really drilling down to I think I wouldn't call it a micro level, but really the lowest level where information is flowing between folks that are in early stages of development in some cases and taking each other's ideas. How much time would you typically spend to generate that kind of a chart?
Yeah, for an office action or for a patent prosecution, it's very little time, really an hour at most. And that alone, I think, can provide some useful information. Now, for the competitive matrix, that does take more time, and it's best to do that when you still when the technology is still in its youthful form. If you've got thousands of patents, that's something that's going to require some software horsepower. But if you're talking about a relatively small number of patents, as was the case for deep brain stimulation, when I prepared the diagram, it took maybe 3 hours or so.
So that's pretty short. It doesn't take long, I guess. And I think last webinar we did, I think Mark gave a pretty good list of all of the various types of platforms where you could get landscape information out of directly. And there are a number of them in the marketplace, and some of them you can sit down in front of and, within a very short period of time, generate some really interesting landscape information. I mean, the downside is that they tend to be pretty expensive, and if you've got enough volume of usage, they're good to have a seat on, and if you don't, it's probably not worth it. So you want to use a vendor that has access to one. But a lot of landscaping work is episodic in nature. You don't do it continuously. Even if you're a large firm like Schwegman, we probably have something going on at all times, but any one client might only do this, once a year or less, depending on how big they are. So with that, I think we're at our time is up. Let's see if there's any other questions in here that came in that we might want to answer before we wrap it up. I don't think so. So, we'll just kind of, finish off by thanking everybody for attending today. We'll see you in a couple of weeks. And certainly the firm has a lot of landscaping capabilities. If you're a client of the firm and you're interested in learning more about that, you can reach out to any one of our panelists from the firm today. and we'll be happy to get back to you ASAP. So with that, I guess we'll wrap it up, and I want to thank all the panelists. You guys did a great job. I appreciate it, and hopefully everyone has a good rest of the week and weekend. Thank you.
Bye-bye.
Bye-bye.
Thanks, Steve. And the next episode of the Patent Analytics webinar series will take place on Thursday, May 14th. It will cover using prosecution analytics to improve prosecution efficiency and identify wasteful, unproductive prosecution spending. Thank you again for joining us, and be well.